Welcome back, everyone, for session 4 of day 2 of the 10th Asia Pacific ADR Virtual Conference. My name is Sally O, your host for today, and I'm currently a case counsel at KCAB International. We are thrilled to have you back and look forward to another day's worth of excellent discussions. Please note that Chinese and Korean interpretations are available, so check the interpretation button below your screen for your use. We will begin right away with our third session. This session will review the current trends and issues in refining rules and structures of investor-state dispute settlement mechanism. For our moderator, we have Professor Hit-Tek Shin. Professor Shin is the chairman of KCAB International, the international division of the Korean Commercial Arbitration Board. He is also an arbitrator for 20 ethics chambers and serving as a governing board member of the International Council for Commercial Arbitration. Professor Shin will be joined by distinguished experts from around the world. I am now pleased to pass the screen over to Professor Shin.
Thank you, Sally, for the kind introduction. Good morning, good afternoon, and good evening, everyone. Welcome to the session 3, devoted to the discussion of reform of ISDS mechanisms. It is a great privilege and honor for me to moderate this session with the eminent experts on the topic today. In response to the waves of voices calling for the reform of investor-state dispute mechanism, settlement mechanism from various stakeholders and civil societies, UNCITRAL Working Group 3, as well as ICSID, have made substantial efforts to address the concerns raised by these stakeholders in recent years. Today, we will review some of the early outcome out of these efforts. Today's discussion is divided into 3 subsections. First, we will address the refinement of investment arbitration rules. We will start with McKinney's presentation on the current status of amendments to ICSID rules and regulations and key features of such amendments as it stands now. When we planned this session, we hoped that the ICSID amendments would have been approved by the conference date. However, apparently, this is not the case. After Mac's presentation, we will hear from Dr. Claudia Anaka regarding the new investment arbitration rules of Vienna International Arbitration Center. While the ICSID amendments have inherent constraints delimited by the ICSID Convention, a multilateral treaty, Vienna rules were formulated without such constraints. Thus, we could see the difference of the approach between these 2 rules. We will then hear from Professor Jin Ho regarding the most recent draft Code of Conduct jointly released by UNCITRAL and ICSID. Thereafter, Dr. Richard Hepp will share his comments on the amendments to ICSID arbitration rules. If time permits, we will have a brief discussion session on the rules. After Dr. Hepp's comments, I will relay questions from the audience to the speakers if you send in questions through the Zoom functions. In the second subsection, we will hear on the UNCITRAL Working Group 3's recent launch of review on the assessment of damages and compensation. We will first hear from Dr. Judith Knipper on this new reform agenda, and then Professor Malcolm Langford and Dr. Jonathan Bonicha will share their comments from academic forum's perspective on damages and compensations. In the final subsection, We will hear from Chang-an Han of the Ministry of Justice of Korea on the efforts of Korea to improve the ISDS mechanism from a state perspective. Unfortunately, there are last-minute changes to two speakers on the program. First, due to unexpected personal reasons, Anna Jubin-Brett, Secretary of UNCITRAL, is not able to join us today. Dr. Judith Nipper will make a presentation in her stead. Dr. Stefan Wilske is unfortunately suffering from a very mean virus infection, which makes him hardly speak. Dr. Richard Hepp agreed to step in for Stefan. Both speakers expressed a deep disappointment and frustration, and they asked me to send the best regards to all of you and audiences. Now, we will start the session with the presentation of Meg Kinnear, Secretary General of ICSID. No introduction would be necessary for her. She has been serving as Secretary General of ICSID since 2009. Due to the time difference between Seoul and Washington, D.C., where she is now, she will present using a pre-taped video. Please.
Good afternoon. I'm really pleased to join you today and to talk a little bit about reform initiatives that have been ongoing in the last year. I'd like to focus in particular, of course, on the ICSID amendments and on an update for the ICSID amendments. I'd like to start with the objectives of the rule amendment. As you know, this was basically an effort to modernize rules based on our experience that we'd had since 2006, which was the prior amendment. We also wanted to address a number of the procedural issues in the reform discussion while maintaining a procedural balance between investors and states. As well, we wanted to provide more options for dispute settlement between parties. We looked in particular at the arbitration and conciliation rules, and while there have been changes throughout, I'd like to focus on some of the main ones that have been most discussed. And of course, on the top of that list comes the provision for third-party funding. The proposed ICSID rule requires parties to disclose the name and address of the funder immediately upon registration, but they are not required to provide the agreement itself or the terms of the agreement unless the tribunal decides that that is relevant and orders otherwise. So we have approached this basically as a conflict of interest mechanism requiring disclosure about third-party funding. While some parties would have encouraged a prohibition on third-party funders, others were not at all interested in a prohibition. And so the ICSID rule comes at this in the perspective of a conflict of interest rule, which is something that everybody was able to agree on. Another area that had a lot of discussion was the whole question about costs. And there was some discussion about whether there should be a cost follows the event type of rule or some other presumptions on costs. We did not change the discretion on costs, which is provided by the ICSID Convention and the ICSID rules. However, we did set out a number of important factors for tribunals to consider when allocating costs. And these, of course, include the outcome, but importantly, the conduct of the parties, including whether they acted in a cost-effective manner, the complexity of the issues, and the reasonableness of the cost claim. You will also know that there is a provision addressing an award of costs to a prevailing party on an application for manifest lack of legal merit. And that presumption is included unless there are special circumstances justifying a different allocation of costs. On the cost topic, there was also a lot of discussion on security for costs. As you know, previously this had been dealt with as a provisional measure, and so you needed to prove imminency or urgency, which was not always something that fits well with a request for security for costs. So the new rules propose a standalone rule on security for costs, And that standalone rule has a specific test, and that is for the tribunal to consider a party's ability to comply with an adverse decision on costs, their willingness to comply with that adverse decision on costs, and then on the other side of the equation, what an order of security for costs might do to the party's ability to pursue its claim or counterclaim. Finally, the conduct of the parties will also be relevant when there is a request for security for costs. So you see that there's a bit of a new regime here for security for costs awards. We have also considered and continued the direction of the past amendments in that we further increased transparency of proceedings and of pleadings. And you will see that in particular, the focus in the transparency provisions is making sure that awards, orders, and decisions are provided to parties. And this, of course, makes a lot of sense because one of the main reform efforts, both at UNCITRAL and at ICSID, has been to address concerns about consistency and cohesiveness of jurisprudence. So a basic place to start, of course, is to make sure that awards, decisions, and orders are available, and so parties will know what is the law and what is the jurisprudence constante on any one topic. We have also included a new provision that specifies what is confidential or protected information and says that that kind of information obviously should not be made public. So the transparency provisions take account of both concerns about something that is legitimately confidential, but also concerns about the transparency of the system as a whole. Another change that was made that perhaps has been less remarked upon, but is an important change, is that the additional facility rules have been made much broader. And I say that in two respects. The first is that the additional facility rules will now be available even if both states are not ICSID member states. So in much the same way as the UNCITRAL arbitration rules have been available, so too will the additional facility rules of ICSID. The second part to the availability is that these rules are specifically open to regional economic integration organizations as a party to the dispute. And of course, that might be as a respondent or as a claimant. And of course, that reflects what we have seen recently, which is increased treaty making by REIOs, and in particular by the European Union. But we know that there are a variety of other REIOs that are considering rulemaking and investment as an REIO. So these additional facility rules will be an important tool in those situations. As well, when we discussed having more dispute settlement options, one of the key things that we decided to include was a set of new standalone mediation rules. And this, of course, responds to requests both by states and investors to provide greater options for mediation. You will see that these mediation rules are available both where a treaty offers mediation or where there's nothing in the treaty, but both parties consent to mediation. In addition, the mediation rules will be available to parties at any time throughout the proceedings. So while this might be something you would see in the cooling off period, for example, it also might be something that parties resort to in parallel with arbitration. They might stay in arbitration process. They might do this towards the end of a case where some things have become clearly able to be mediated. And so there's a lot of flexibility in the new mediation rules. In terms of next steps, I think we are on the cusp of getting this project done. We had over the pandemic received several comments on what was then the most recent working paper. That was working paper number 5. And during this period, a number of states told us that they were ready to go to a vote. So in November of 2021, next month, this month, we will be issuing a final working paper with several small changes, and we will be issuing the full set of rules as they stand after all of this process. That will give states the ability to reflect upon them, and then in January of this year, likely, we will be requesting a vote by correspondence. And assuming that vote is successful, we would then be in a position to implement these rules, likely in about the second quarter of 2022, and then we will all be able to start practicing under the new amended ICSID rules of procedure. So this is a short, but I hope a helpful overview of the reforms that we've been working on in the last year. Thank you.
Thank you very much, Meg. It is very helpful in understanding the overview of the of the ICSID amendments and what was most importantly explained or presented to the audience, and also we now have clear idea of the timeline of when it would be presented for voting and when would become effective. We will move to our next speaker, Dr. Claudia Anaka, who is a partner of Deckard in Paris office. She is recognized as a leading lawyer and expert in international arbitration, in particular, investor-state dispute and interstate dispute. She is on the ICSID panel of arbitrators and on the board of Vienna International Arbitration Center. Claudia, the floor is yours.
Thank you very much. The Vienna International Arbitration Center's new investment arbitration rules are a standalone set of arbitral rules specifically tailored for investment arbitration. The Vienna investment arbitration rules are based on the standard Vienna rules for commercial arbitration, but they contain a number of special provisions and of modifications that address issues specific to investment arbitration. As such, the rules combine elements of the Vienna commercial rules, in particular party autonomy and procedural flexibility, and those of specialized investment arbitration rules. When do the Vienna investment arbitration rules apply? The rules may be applied by agreement of the parties to any type of dispute. So disputes arising under contracts, under treaties, under domestic legislation, or any other instrument. Now, the rules are designed to resolve international investment disputes involving states, state entities, and international organizations, but there are no objective requirements regarding the parties or the subject matter of the dispute. So this is one of the key differences compared to ICSID arbitration. Claimants only need to satisfy the investor and investment definitions and other requirements of the applicable investment treaty or law. And the parties can thus avoid the time and cost of arbitrating the jurisdictional requirements of Article 25 of the ICSID Convention, over which ICSID tribunals have split. Now, arbitration under the Vienna investment arbitration rules is available to all states, their constituent subdivisions, state entities, as well as private parties. In addition, international organizations may also agree to arbitrate under the rules. There are again no objective requirements regarding nationality or restrictions regarding state entities or state agencies. The Vienna investment arbitration rules directly address a number of challenges that investment arbitration faces, notably inefficiency and cost. In doing so, VIAC benefits from the fact that it is free from treaty constraints. So let me give you two examples how the Vienna investment arbitration rules address these challenges. The rules streamline and expedite the arbitrator appointment process, which is very important to reduce the overall length of the proceedings. The constitution of an ICSID tribunal on average takes nearly 7 months from the registration of the case. Under the Vienna investment arbitration rules, if a 3-member tribunal is to be constituted, all arbitrators must be nominated within approximately 90 days. Now, claimant must nominate its arbitrator in its first submission, its statement of claim, and the respondent in its answer to the statement of claim, which it must submit within 60 days of receipt of the statement of claim. Now, the chair must in turn be nominated by the co-arbitrators within 30 days of the Secretary General's request. Now, critically, if any of these deadlines is not met, then the VIAC board automatically proceeds promptly to appoint the arbitrator. The ICSID arbitration rules, by contrast, do not impose such deadlines. They do not impose any deadline on the claimant to appoint the arbitrator, nor on the respondent state, other than to promptly, upon receipt of the claimant's notification of its arbitrator. The chairman of the administrative council may appoint an arbitrator, but only upon the request of a party, which it may make at the earliest 90 days after registration of the case. This appointment process is prescribed by Article 38 of the ICSID Convention. It can therefore not be changed by way of rule amendment. A change would require an amendment to the ICSID Convention, which in turn requires agreement of and ratification by all 156 contracting states in accordance with their constitutional requirements. Now, my second example is timing of the awards. The Vienna investment arbitration rules contain time limits for the issuance of awards. This is again very important to reduce the length of the proceedings. In the last 2 years, investment tribunals have on average taken more than 500 days from the last hearing to render their final awards. Under the Vienna rules, awards must be rendered no later than 6 months after the later of the last hearing or the last authorized submission. Now, the VIAC Secretary General may extend this 6 month deadline, but may also decrease the arbitrator's fees by up to 40% for inefficient conduct of the arbitration. In addition, the VIAC board may remove arbitrators who unduly delay the proceedings. ICSID tribunals, by contrast, must issue their awards within 120 days after closure of the proceedings, but they have full discretion as to when to declare the proceedings closed. So they typically do so after they have completed their deliberations and are close to finalizing the award. Under the amended ICSID rules, the period for rendering an ICSID award will be triggered by the last hearing, but the tribunal's obligation to meet time limits is only a best efforts obligation. Let me now give you two examples of special provisions that are only included in the Vienna investment arbitration rules, not in the Vienna rules for commercial arbitration: non-disputing party submissions and summary dismissal. In investment arbitrations based on treaties or laws, non-disputing parties may seek leave or may be invited by the tribunal to make written submissions on any legal or factual issue within the scope of the dispute. In addition, a contracting party to the treaty providing consent to arbitration that is not a party to the arbitration may make written submissions on questions of treaty interpretation. And it may do so without the consent of the tribunal or the parties. This right of non-disputing treaty parties protects the contracting parties' interests in ensuring accurate treaty interpretation, and it may also assist the tribunal greatly in interpreting a treaty. The amended exit arbitration rules and the antitrust transparency rules contain a similar provision. Now, another special feature of the Vienna investment arbitration rules is summary dismissal. Now, the rules permit a party at any point of the proceedings to apply for summary dismissal. Summary dismissal of claims, counterclaims, and defenses. Now, the scope of the summary dismissal procedure is broad, covering, in addition to manifest lack of legal merit, manifest lack of jurisdiction, and manifest inadmissibility. As to timing, a request for early dismissal may not only be made at the outset of the arbitration, but also later, if and when an issue arises that lends itself to summary dismissal. And the order or award on an application for summary dismissal is to be made within 60 days of the last written submission. This early dismissal provision is more flexible than the corresponding rule of the exit arbitration rules, Rule 41.5. Now, the scope of Rule 41.5 is limited to claims, and early dismissal must be requested within 30 days under the amended rules 45 days after the constitution of the tribunal. To conclude, the Vienna investment arbitration rules aim at introducing important incremental changes in investment arbitration. We have prepared the rules to offer a cost-effective alternatives to the rules traditionally used in investment arbitration, especially for smaller claims and parties that prefer arbitral rules shaped by continental European procedural principles. Thank you.
Thank you very much, Claudia. It is very helpful in understanding the key difference between exit amendment of rules under the constraint of the exit convention, and also freestanding the Vienna rules. We will move to our next speaker, Professor Jean Ho of National University of Singapore. She lectures and supervises on diverse aspects of international investment law. Prior to academia, she specialized in investor-state disputes at one of the leading law firms in this field, Shearman & Sterling. She will talk on the draft Code of Conduct jointly released by UNCITRAL and ICSID recently. Jean, please.
Thank you very much, Professor Shin, for having me. I am very honored to be here today. It's my pleasure to present my views on the UNCITRAL Draft Code of Conduct for Adjudicators, Joint UNCITRAL Exit Draft. I'd like to make a disclaimer at the start. I happen to be the Deputy Chair for Research at the UNCITRAL Academic Forum. So I must say that everything I'm going to say next is said in my personal capacity. It doesn't represent the views of the academic forum, and it certainly doesn't represent the views of the steering committee members, one of whom is also here today. So that's Malcolm Langford, very good colleague of mine. So with that out of the way, let me get started. Also, I'd like to just sort of give the audience a heads up that what I'm about to say next may sound rather outrageous and upsetting, but it's only going to be 10 minutes, all right? So I think you can bear with me till the end of it. What I'm going to do is I'm not going to be walking everyone through, every single provision in the draft code, because I've only got 10 minutes and everyone can read the draft provisions for themselves. It's freely available online. So I'm going to zero in on one aspect of the draft code, which I find very interesting. But before we get there, perhaps as a primer, let me just go through very briefly why the draft code is even there in the first place. So over the past decade or so, with the system of investor-state arbitration picking up steam, you have a lot of disputes, a lot of arbitral appointments. Some problems have been perceived and some problems have emerged. And these have been identified by ICSID and UNCITRAL, as double hatting. This is where an individual acts as both an arbitrator and as a counsel in investor-state disputes. That could give rise to sometimes a conflict of interest, lack of impartiality on the part of the individual. It's also given rise to issue conflict of bias. For instance, if an individual has sat on a tribunal before and decided a dispute in a certain way, if that individual proceeds to sit on another tribunal hearing a very similar issue, there's a suspicion that the individual could decide in the same way. So that's not good for the party that's on the wrong side of the dispute where that individual arbitrator is concerned. And of course, all this gives rise to a perceived lack of impartiality or a perceived bias on the part of the arbitrator. And that gives rise to very serious concerns, because in investor-state disputes, arbitrators are the judges. They decide what happens in any given case. So if an arbitrator were to come across as having prejudged the dispute in favor of one party or another, I think that really undermines the legitimacy of the whole process. So the reason why these problems have emerged have a lot to do with the phenomenon of repeat appointments that we see in the field. We don't get this that much in national courts, and we don't get this that much in international commercial arbitration, because the pool of arbitrators that you get to choose from is actually very large. In investor-state disputes, however, in the first place, you don't have that many disputes every year. When you talk about having 100 disputes a year or 120, that's a far cry from the number of commercial arbitration disputes or national litigations that you will have. So it's quite a small number. And the number of people qualified to sit as arbitrators to hear these disputes is, again, rather small. So you end up having certain individuals, because they have a track record of serving as arbitrators in these disputes, who get appointed again and again and again, right? So I think at the last count, based on some empirical studies, we have about maybe in the ballpark of 30 arbitrators out there who get a lot of appointments, so they've really cornered the market in terms of the of being an arbitrator in ISDS. So there are a lot of concerns, and as a result of which there's been a lot of talk, a lot of discussion, and then we have now a draft code of conduct for adjudicators. The draft code of conduct, I think, sets a very, very high threshold for the individuals who plan to serve as adjudicators. And the point in the draft conduct that I'd like to zero in on today, spend a little bit more time unpacking, is this requirement which I find almost an impossible requirement that's found in Article 3 of the draft code, which states that adjudicators are not supposed to be influenced by self-interest. So the notion I want to unpack today is this not, you cannot be influenced by self-interest. At first glance, I found it rather, well, okay, that's a very high standard to meet for someone to not be influenced by self-interest. And on further reflection, I found that rather harsh on adjudicators to tell them not to be influenced by self-interest. It's rather counterintuitive when you think about it. The human species, any species, living species, it's a rule of nature, it's a law of nature to act in your self-interest. Because if you don't act in your self-interest, you will perish as a species. And I think, I'm not sure if it's just coincidence that I'm speaking today on this topic, because just the day before, we have learned about a very high-profile disqualification of an arbitrator in a treaty claim with Poland as the respondent state. So Kaczobert, I'm sorry if I massacred his name, I try to do it the French way, I'm not sure if it's pronounced correctly, but Kaczobert, Swiss arbitrator, was disqualified for failing to disclose that he was previously appointed by Poland as its arbitrator in a dispute involving fairly similar issues. So this challenge was raised by claimant counsel, and then Professor Hobert admitted that he did not disclose this material fact, and the final ruling is a disqualification for arbitrator Hobert. So you would wonder, well, now that we've come this far, right, there's a version 3 of a draft code of conduct, and yet you still have such eminent individuals failing to disclose what many people would regard as a material fact, prior appointment by one of the disputing parties in a dispute involving similar issues. And all I can think of is, A, maybe it slipped his mind, but B, why would I knowingly say no to an arbitral appointment? Because I trust myself to act impartially in both cases. So as an individual, I don't see any problem accepting both appointments, which is why Professor Hobert did not resign immediately, I would imagine, upon being challenged by claimant counsel. He chose to stick it out, but unfortunately, the result was that of disqualification. We have seen similar episodes with other very eminent arbitrators, the ones who receive many appointments every year, and the results vary. Some resign immediately, maybe because they don't want to be dragged through the process of disqualification. They don't want to have to explain why they did not disclose that material fact. But the long and short of it is that people act this way. Very eminent arbitrators act this way, and everyone, not just eminent arbitrators, they act this way because self-interest is paramount. When an individual's practice, his source of income, is primarily that of arbitral appointments, you're not going to have people turning down appointments in the interest of the greater good. That would not make very much sense. So the system, as it stands, in my view, is one that prioritizes, it's one that incentivizes self-interest. So to ask adjudicators to not act in self-interest, I think it's a near impossible order. So what's to be done? If adjudicators are not the correct target for this reform, what do we do about repeat appointments? What do we do about the likelihood of issue conflict, double hatting, so on and so forth? In my view, I don't think it's right to think about this in terms of apportioning blame. But one solution, possible way out of this, is to provide an option for the appointment of arbitrators to be done by the arbitral institution instead of by the parties. Because when you have party appointment of arbitrators, the same notion of self-interest arises, because parties counsel will act in the best interest of their clients, be it respondent state or be it claimant investor. And it's in the appointing party's best interest to select arbitrators who are most likely to rule in favor of their client, be that client an investor or a state. So once you take party appointment out of the picture, in my view, or at least contemplate the likelihood of replacing party appointment with institutional appointment of arbitrators, I imagine that a lot of the problems that we're facing today with issue bias and perceived lack of impartiality, that's going to go away without forcing this hapless group of arbitrators to stop acting in their self-interest. Thank you.
Thank you very much, Jean. That's very, very insightful, but at the same time, as you want at the outset, some of the arbitrators or some of the stakeholders, some may feel very relieved to hear that, but at the same time, some may feel that it's very harsh system on the adjudicators. And because of the time constraints, we will move to Dr. Richard Hebb, and first hear his view or his comments on the ICSID amendments. Dr. Richard Hebb is a partner of Luther, a German law firm with expertise on arbitration in energy, real estate, and infrastructure industries. Dr. Richard Hebb is a co-editor with Stefan Wilske of a commentary on the amendment to ICSID rules, planned to be published when the amendments to ICSID rules will take effect. I must disclose that I am one of the contributor of the chapter, contributor of the one chapter in that book. Richard, would you please?
Thank you, Itek. It's a great honor to be here and to have been invited to speak in front of such a distinguished audience. Let me share some slides. Wait, whether I can do this. Share. And now presentation. Good. So I have been asked to speak about the new ICSID arbitration rules and what's new and why it's new. And I'd like to modify the question a little bit. Are they really new? And I think in a nutshell, the answer is no, but let me explain. You can group the amendments into four main groups. The first are amendments where the ICSID rules are brought up to speed by including international standards. The second one are amendments which reflect specific ISDS concerns, like, for example, transparency. The third one are very welcome amendments which codify existing practices. When you do ICSID arbitrations, you soon note that there are certain ways how matters are done. You discuss certain concepts, I'll come to that in a minute, which you will not find in the rules, but which everyone active in ICSID arbitration knows and knows how to use. They are now to a certain extent included into the rules, which is very good. And lastly, the ICSID amendments which regulate certain disputed issues, I call that gap filling. Let me go a little bit into details. The first group are the amendments which introduce international standards. These, I submit, are not new. We have not really. We have, for example, an expedited arbitration mechanism, which will become chapter 12 of the new rules. That is, of course, new for ICSID, but it's not new for experienced users and practitioners in the realm of international commercial arbitrations, because other rules have such expedited mechanisms too. And frankly speaking, ICSID did not completely reinvent the wheel. They, of course, drew on existing rules. So everyone using this will have an understanding of how it should be used. Then there is, for example, the obligation to hold a case management conference, which is very which is very good, which is also not new. You have it, for example, in the ICC rules of arbitration and in the SCC arbitration rules. You have an electronic filing of documents, which is very, very welcome. I recall that when we filed a memorial in a case against Spain, and that was bilingual in English and Spanish, with all necessary 5 copies in 2 languages, we sent nearly a ton of documents to Washington for something like 15,000 euros. So electronic filing of documents makes life easier, and you also have it in other arbitration rules of other arbitral institutions. And you have third-party funding, a requirement for disclosure, which is also not new. You even find it in the new ICC arbitration rules, which you may consider to be the gold standard for international commercial arbitration. Then, as the Secretary General, Ms. Kinnear, already pointed out, you have certain amendment which reflects specific ISDS concerns, and that is mostly Chapter 10, which increases the overall transparency of exit proceedings. So you now have very detailed provisions on transparency and on amicus intervention, which, even as a practitioner who mostly so far represented claimants, I find very welcome, because they remove a lot of potential for dispute. You have it in every exit case which you currently start. You have discussions about the scope of transparency, and it's good that exit now removes this from the scope of the discussion. You then have certain amendments which merely codify existing standard practices. For example, you had in the existing exit rules the provision to have a first session and a preliminary procedural consultation. This is now combined into first session. And as every one of you who've done exit arbitrations will agree with me, that's anyway standard now for at least the last 20 years. There will be first session where both of them will be discussed. The exit rules provided that you have only 1 round of submissions unless the parties agree or the tribunal considers it necessary to have 2 rounds. I've never seen an exit case with only 1 round of submissions. It's always 2 rounds, so that's now in there. As Ms. Kinnear pointed out, you now have some more guidance on costs, but that is also not completely new. It's based on existing practice and on existing case law. And also quite welcome, because I've just ended the suspension of a case, a discontinued one. You now have rules of suspension. It's quite a common procedure to suspend exit proceedings, for example, when you discuss a settlement. But there weren't really any rules on how to do that and what the effect would be. You now have that, so that's very good. It removes a source of contention. Then you have rules which fill gaps. Rules which so far were not in the exit arbitration rules, and rules which are necessary because they usually lead to discussions. One of them, for example, is bifurcation. So far, decisions of tribunals on bifurcation were based on arbitration rule 19. And you had to operate very much with prior case law to argue what requirements for bifurcation is, when you can do it, and how the tribunal should be guided in its discretion. You now have specific rules on that in the new arbitration rules, which is very welcome. Same with security for costs, a much disputed issue at the moment. You now have a specific rule on that. Also very good. It's gap filling, which is very welcome. And you have, for example, a rule on consolidation of proceedings, which also has not been regulated before. So in a nutshell, nothing in the new exit rules is really new. If you're an experienced arbitration practitioner, you'll find the changes somehow familiar. You have a simplification and you have a modernization. But If you're familiar with the provisions and the amendment mechanism, you'll note the following. Firstly, the new rules are a patchwork of old and new provisions. Secondly, many provisions have now been revised a couple of times. As Ms. Kinnear pointed out, there have been 5 working papers, and there will now be a 6th working paper with the final rules. That means that original ideas have been changed and amended quite a couple of times, and often due to political compromises. Not always will you find the reasons for those changes in the working paper. Sometimes you can, when you look specifically at what certain states requested, you can deduce that likely change was due to that, but you will not really know that for sure. The arbitration rules, like treaties, would need to be interpreted by the wording and their context and in the objective purpose. And this is where still problems arise, because when you import concepts used from in commercial arbitration rules into the exit arbitration rules, you change the framework and the potential application. So uncertainties arise how you should apply those familiar rules in an exit framework. I'm looking quite forward to the first case of expedited exit arbitration to see how this will work out, because a state as a respondent is not the same thing as a company. States and investors are not equals. And this is sadly still in procedure always apparent. Then there's the question, how do you interpret the political compromises? Can you draw on the travaux? To what extent? And most interestingly, which existing case law is applicable to the new rules? As those of you who've done investment arbitrations know, nowadays it's so easy to draw on precedents due to databases like Jusmundi or Investor State Law Guide, that memorials are filled up with quotations, often sometimes only a sentence or two, and parties then say, oh, well, you need to do this because prior tribunals have also done it, see the decisions, and then you get a long, page-long footnote. Now you'll need to check and assess whether the existing case law still applies under the new rules, because a lot has been changed. So, in short, while there's not something really groundbreaking, by introducing, updating, and modernizing the rules, there are a lot of new possibilities, let's say, for disputes, for diverging interpretations, and for the need of tribunals to give their views on what essentially are new provisions in their context in the exit arbitration rules. Thank you very much.
Thank you very much, Richard. It is very helpful to understand the new rules and also its broader ramification from practitioners' perspective. I hope that we could revisit this issue this time next year to test how the arbitration community, especially the councils, react or utilizes this new rule if the new rule entered into force in the first quarter next year. As we are slightly behind the schedule, I will just move to subsection 2 and reserve the discussion towards the end of the session if time permits. We will now turn to the issue of damages and compensation. UNCITRAL has posted an initial draft on assessment of damages and compensation it prepared at the request of Working Group 3 as one of the reform agenda of ISDS for comments by delegations. Our first speaker on this subject is Dr. Judith Nieper. Dr. Nieper is a legal officer at the Secretariat of UNCITRAL in Vienna. She is deeply involved in the damages and compensation issue at etc. Judith?
Yes, good morning, good afternoon, good evening all. Before starting, I have to send best regards from Anna Joubin-Brett, our secretary, who was scheduled to do the presentation. She cannot do so for personal reasons, and she really sends her apologies for that. Further, before really starting, I have to, do you see my screen now?
Oh, yes.
Yes, perfect. So before really starting, I have to thank our co-organizers, KCAB, ICC, and of course the Ministry of Justice, and not only for the organization of this event, but for long-standing cooperation. This is the 10th anniversary we are celebrating during this conference. And what I would also like to highlight at the outset is that this is also the 10th anniversary of AirCap. So they have been involved since, or we have been involved since the very beginning of these conferences, and we do hope that many more events and anniversaries are yet to come, and I'm very optimistic that this will happen with Atita being on board and having already received a number of ideas for future events during the first days. The topic I'm going to deal with is the topic of damages, assessment and compensation, which is a highly complex topic, but with broad practical significance. And there are indeed several reasons for both the complexity and for the significance. First, it's an area that reaches the boundaries of public international law. It's a topic on which treaties generally provide very little guidance. Indeed, treaties usually only relate to lawful expropriation breaches and are otherwise silent, the majority of them at least. So awards for the compensation of damages resulting from unlawful expropriation or the breach of other treaty standards are usually derived either from the principle of full reparation under customary international law, or following the lines of the standard of lawful expropriation, and the appropriateness of both approaches have been heavily questioned. Further, the issue is between procedural and substantive law, and it is difficult to determine where the first begins, the second ends, as both are closely intertwined. And last but not least, the topic is of high significance because of the high amounts that are usual or that might be awarded. And this is also the reason why especially developing states insisted very much on having the issue on agenda of Working Group 3, which deals with the reform discussions on investor-state dispute settlement. So this ambiguity of the distinction between procedural and substantial matters is one of the main reasons why the topic of damages has been addressed cautiously, as Working Group 3 focused its work primarily on procedural issues. Nonetheless, the mandate that was given to the working group by the Commission in 2017 is specified as a broad one. So the assessment of damages and compensation as such was not among the 6 concerns that have been identified by the working group initially, but it has rather emerged gradually in the context of other concerns, especially with regard to consistency, correctness of the decisions, and it has gained more and more attention over time. So the Secretariat was requested at the 38th session of the working group to have a closer look at at the topic. And this is what we did. We prepared an initial draft on the assessment of damages and compensation. You see a red arrow on the slide, and it's red to highlight that there is a deadline coming up. This is the deadline when we hope that we receive comments by delegations so that we are enabled to improve our current draft, to fine-tune it, to include other aspects that states might wish to discuss or other ideas. To date, we have received very little comments. We received some comments during a webinar we organized together with the academic forum in August. And I'm happy that we do have two representatives later going more into the details of the session. And maybe this is also a good opportunity to thank the former chair of the academic forum, Malcolm Langford, who assisted very much in preparation of all of our papers. So 15th of November is something when we would hope that our email box is receiving a number of emails by you. One word on the complexity and the uncertainty. These were issues that have been stated by a number of states in their submissions, and it is considered to be one of the key factors that contributes to the cost increase of ISDS procedure and negatively impacts correctness, consistency, and predictability. And what we try to do in the note is highlight some of the 10 parameters we found that might deserve further discussion and clarification, and you see them here on the slide. So you have, of course, the compensation standard that was already mentioned. So particularly for cases of non-lawful expropriatory breaches, you have the valuation method, which is crucial, and there, in particularly the appropriateness of the so-called discounted cash flow method, the DCF method. You have, of course, the valuation days. You have potential limitations for compensation, particularly considering the claimant's conduct before the breach and also the amount that was invested. You have causation standards. You have the evidentiary requirements, standard of proof. You have the calculation of interest, and there you have especially the issue of pre and post award interest, and more importantly, the issue of compound interest, which might lead to very high amounts in the award. You have selection of experts, allocation of costs, and the primacy of restitution over compensation, and this is something that changed over time. So the question before the working group would be if some or all of these points should be addressed by developing either model treaty provisions, guidelines, or standards for tribunals on these issues. You have also the big issue, and that was already said, the high amounts of the awards, which is the main concerns as an outcome. And what we witness is a significant discrepancy between the amount of compensation claimed and the amount of compensation awarded. And closely related, connected with this is the wide divergence of compensation presented by claimants and respondents experts. What was mentioned in submission by states is that this so-called anchoring effect, where an exaggerated claim is made by an investor as a legal tactic relying on tribunals to consider the claim as a reference for the calculation of compensation. And this is highlighted as being a serious issue of concern. So again, this is something that the working group would need to address. There are various proposals in the note, and I will not enter into them for the sake of time. And then, as already mentioned, or as mentioned in all of our presentations, we are looking at the whole ISDS reform process, which means that we look at none of the topics on its own as a standalone topic, but we try to keep the whole picture of ISDS reform into mind and see where we have the interlinkages and where the issues are intertwined. And in the case of damages and compensation, you have them on the slide. These are the reform options where we see that there are interlinkages that we would need to tackle in particular. So to conclude, I have to recall that we really very much appreciate your comments that we would need before the 15th of November so that we could fine-tune our draft properly and address what is of interest for states. What I would also like to do, and this does not relate purely to my topic of today, is to take the opportunity to inform you on 2 points that are currently of interest at the working group. And this is that at the level of the General Assembly, we are currently having discussions on the allocation of additional resources for working group 3. So this we will receive a decision probably by the end of the year. And then I would like to highlight, and we already got a very good introduction into the topic, that from the 15th to the 19th of November, the working group is again meeting, and the topic for that week will be exclusively the code of conduct. So some of the points that have been highlighted today will certainly be discussed. And with that, I'm looking forward to a more substantive presentation by our colleagues from the Academic Forum. Thank you very much for your attention.
Thank you very much, Judith. It was a very good overview of the background of the issues and also the kind of task of the working group to develop. And I think that is one of the most important but challenging issues for working group 3. And on this issue, on August this year, Academic Forum on ISDS made a presentation of a paper on damages. And Malcolm Langford and Jonathan Bonnicia are co-authors of this Academic Forum paper together with 2 other colleagues. Dr. Malcolm Langford is a professor of public law, University of Oslo, and director of the Center on Experimental Legal Learning. He was a former chair of the Academic Forum. Dr. Jonathan Bonnicia is a senior lecturer in law at the University of New South Wales in Sydney, Australia. His primary area of research interest is in international economic governance, with a particular interest in investment treaties. They will speak on the academic perspective on damages and compensation. Would you please, Jonathan and Malcolm?
Thank you very much to the organizers for the kind invitation to us to present this paper, and particularly coming after so many distinguished guests on the panel. As noted, we've written a paper on damages for the Academic Forum, which will shortly be published in the Journal for International Dispute Resolution. You'll also find it on the Academic Forum website. When the Working Group 3 process started at Unisatral in 2017-18, damages was not on the agenda. This was because it was thought it was a more substantive issue, and the working group process was to focus more on procedural reforms. But for three reasons, it's come onto the agenda. Firstly, developing countries in particular have raised a concern over very high levels of damages. There were presentations, for example, by Pakistan and Nigeria in the working group sessions. Secondly, it became less clear whether damages was a procedural issue or a substantive issue, because various aspects of the process could influence the magnitude and the nature of damages. Thirdly, during the process, it became clear that some procedural mechanisms could help states better reform or more easily reform the substantive aspects of their treaties if they wish to do so. So damages, as Judith has indicated, has now come onto the agenda with a specific request by states for the Unisatral Secretariat, with the support of the Academic Forum, to look into this issue. What could be done and to what extent is it procedural or substantive reform? I'm going to quickly go through some of the trends in damages awards. Jonathan will then look at concerns relating to the calculation of damages. And the four concerns that we look at here are actually four of the 6 general concerns that the Working Group 3 has been concerned with, as Judith indicated. And then if we have time, we'll briefly look at some of the reform options, procedural and substantive. So if we look at the overall trend, it goes in one direction, and that is upwards. Both the average damage award, i.e. the mean, and then also the median, where we find most damages awards on a scale, has been increasing over time. And we see this in a number of studies. It's of course difficult to measure this. You can have different criteria as to which cases you include, whether you adjust for inflation or not, and whether you include the big cases like UCOS, which have major damages awards. So let's take one database, which Jonathan has particularly worked on. It uses nominal US dollars, and this particular graph excludes the UCOS cases, which were the 3 multi-billion-dollar cases against Russia. And there you can see basically a tripling of the size of damages awards over time, and particularly over the last 10 years, if you look at the historical averages. And if we look at the median here, we see though the cases cluster in the middle between 10 to 100 million US dollars, but we do see some cases emerging over the $1 billion mark. And then if we go to the PITA database at Pluricourts, which includes slightly more cases than the UNCTAD database, particularly back in time, we've also adjusted for inflation. And if we include the 3 major UCOS cases, we see a 180% increase in damage awards over time. If we exclude these cases, we see only a 16% increase. So different ways of measuring the trends, but the overall message is that we've seen an increase in damage awards over time, which has raised concerns about how tribunals calculate damages and how treaties are formulated in relation to damages and compensation. Jonathan.
Thanks, Malcolm. And turning then to the analysis of the paper, as Malcolm explained, we approached the question of damages through the framework of these concerns that had already been identified in the Unisatral Working Group 3 process. And the first of these was concerns about correctness. So the correctness of decisions in ISDS relating to damages. And this is a difficult concern to assess because, as we heard from Dr. Nieper, there's very little detail in investment treaties themselves about the appropriate approach to the calculation of damages, which means there's potential for a wide range of views, and it can be difficult to say which of those views is correct. People genuinely disagree. But even with this caveat in mind, we do see some justification for concerns relating to the correctness of approaches to damages in ISDS. And two that I'd particularly like to highlight are the first on these slides. The first is the increasing use of the discounted cash flow valuation method. So this is a way of valuing investments or losses pertaining to a particular investment by estimating the future income that an investment would have had with and without the breach of the treaty. And so in the ILC's articles on the responsibility of states for internationally wrongful acts, we see in international law at the beginning of the 21st century a very cautious approach to the use of DCF methods. So the idea that DCF methods should be used rarely and only in relation to valuing the losses of legally protected future interests. For example, guaranteed entitlements to an income stream under a contract. And this contrasts with the approach in ISDS that we're seeing now, where DCF methods are used much more widely. Another concern related to correctness is the use of ad hoc adjustments in valuation. So simply put, this is a practice that seems to happen in some arbitrations where the investor's pleadings are accepted as the anchor or the basis for the damages calculation. All the assumptions that are plugged into the investor's valuation are thereby accepted, and then any adjustments made to qualify the investor's claim are made after the fact. So the fact that maybe the valuation model looks a little bit ambitious, instead of reworking the valuation assumptions and rerunning the model, adjustments are applied in an ad hoc manner, for example, a 50% reduction to take out into account the fact that the investor may have been unrealistic about certain sorts of future expectations. The concerns relating to consistency are much easier to pin down, and we can do this by comparing factually similar cases and identifying some of the differences between tribunals' approaches in relation to those. These are also much well known, and perhaps the most prominent examples of inconsistency are in the choice of valuation techniques in very factually similar cases. So an example is the question of whether it's appropriate to use discounted cash flow valuation methods to value mining investments that were indirectly expropriated while they were still at the planning stage. So there was actually no mine yet. And this choice of valuation method can make a huge difference to the outcome, often leading to figures that are 10 or 20 times as high. And so we see different approaches to that question in two cases, Bear Creek and Tethyan Copper. We're also seeing inconsistency in the way that tribunals build the counterfactuals within the DCF method. So those who are familiar with valuation practice will know that part of building DCF models is building a future counterfactual, and that future counterfactual embodies legal assumptions about the future regulatory environment that would have existed in the absence of the breach of the investment treaty. And these are quite difficult legal questions because, of course, if the host state had not breached the investment treaty, it still would have had a range of legitimate action consistently with the treaty to change the way it regulated an investment. So this is another example of where we see tribunals in essentially identical cases arising in the Spanish solar industry relating to the same regulatory changes, where tribunals have taken quite different approaches. A third concern relates to the costs of the damages phase of proceedings. And this is a more difficult concern to evaluate because we have very little data that allows us to identify the extent of costs that are specifically associated with the damages phase of proceedings. But it's widely understood in the field that the complexity of the damages phase and the involvement of damages experts are major drivers of costs within ISDS proceedings. And in one extreme example, this is not at all a representative case, but to show just how much this part of the proceedings can cost. In the Tethyan Copper case, the claimant spent $22 million just on the damages phase of the proceedings alone, and Pakistan spent almost $10 million itself. So we're seeing more than $30 million just going in legal and expert fees just on the damages phase of proceedings, which reflects the complexity, but also the amounts at stake. And finally, this links up to a point that Jean was making earlier. Damages also intersects with wider concerns about independence and impartiality in ISDS generally, and particularly the practice of double hatting. So on this slide, we have an example of a case, ISA versus Spain, where an arbitrator where an arbitrator's association with the damages expert in several other cases in which that arbitrator was acting as counsel ultimately led to the decision of the tribunal being annulled. So I think our time is up, but just to say that I hope we've encouraged you to take an interest in this subject, and in the paper of the academic forum, we do go on to explore procedural and substantive reforms that might be able to address some of the concerns that we've provided a sort of summary of in this paper. Thank you.
Thank you very much, Malcolm and Jonathan. It's a very important issue. Ultimately, I think the award is issued in terms of the actual monetary value. And so it really requires the international arbitration community councils and the arbitrators focus or pay attention, more attention on those damages issue. And I think that the UNCITRAL paper and also academic forums paper set a very good ground for further review and discussion on this very important but somewhat ignored issue in this field of law. We are already 4 minutes behind our planned concluding time. With your permission and also exercising the authority of the moderator, I will slightly extend our session time and ask Mr. Changwan Han to share the Korea's experience or Korea's efforts in improving the ISDS dispute. Mr. Changwan Han is the director of the Ministry of Justice of Korea, and his department is in charge of defense of the treaty-based claim against the Republic. So he is one of the very most important person from the Korea's treasury point of view. Mr. Han, please.
Thank you, Professor Shin, for the floor and having me today. I should say that it's a great honor for me to be speaking today along with other distinguished speakers. I'm going to talk about state perspective on ISDS regime and rule amendment. But because of the limited time I have, I'm trying to be brief, and I'm going to share my screen now. Okay. But please note that this is not the official view of the Republic of Korea, but my personal view as a government official myself. With that in mind, I first want to mention the laws of state in terms of international investment treaties and investment dispute. When it comes to investment arbitration, states inherently ought to play multiple different roles in a simultaneous manner. There are, I think, mainly 4 different roles for state in the ISDS context. First of all, obviously, a state is a political entity answerable to the public, and therefore, the government should take the concerns of the public seriously. And second, a state is also a contracting party to international investment agreement, which means that a state itself is a legislator when it comes to investment treaty. A state is also respondent in investment dispute, and finally, a state can be the home country of a claimant of its own national in investment dispute. Turning then to the nature of dispute, investment dispute by their nature are not purely economic or commercial, but also political with social dimensions, potentially involving political implication. The dispute also often contain other matters such as environment and labor issues. So accordingly, states can have different priorities and even varying priority per case they are involved and their respective circumstances. So a phenomenon we see lately in the ISDS regime is the rapid growth of the number of investment disputes. Such an increase in turn had raised awareness among states, civil society, and other stakeholders of the ramifications of investment agreements. This in part would have to do with how the agreements are negotiated, what the level of balance stricken between the extent of investment protection and promotion warranted in an investment agreement, and the preservation of the state's right to regulate or policy interest. In the meantime, ISDS defense capacity of disputing parties can also be at different levels among states and claimants as well. For example, for state defense capacity may differ on the basis of whether the state is a capital exporting country or capital importing country, or even whether the state native or official language is English or non-English. For claimant, whether you are a multinational company or a small and medium-sized company, or whether you are just an individual investor and not a corporation, can affect you dealing with dispute and making your own case. So considering all these factors, ISDS can be a matter of survival in my view. ISDS is a regime that was actually introduced only recently with a relatively short history. At the time the system was first introduced a few decades ago, the proliferation the regime enjoys now was not expected or foreseen, in my view. On the other hand, despite its significance, the ISDS mechanism may possibly not live long, and in the long run, may ultimately be eliminated or terminated. The ISDS regime may already be at a point of crisis, especially since the confidence in ISDS regime put by the legal community is at its lowest level nowadays. Given this, the IS reform efforts manifested over the years and still ongoing are important in order to render the existing ISDS regime a more reliable and effective mechanism. In that sense, the ISDS reform project of Working Group 3 of the UNCITRAL and amendment efforts of exceed rules and regulations are really important. As we have seen over the last couple of years, a so-called new generation of investment treaty has been emerging, and I believe this trend will persist. For instance, in the past, most of investment agreement contained very few provision on ISDS procedure, but recent agreement showed the tendency of incorporating innovative approaches and regulating various aspects of arbitral proceeding. In the near future, in my view, it seems likely that substantive provisions, the investment agreement would be put on the table for discussion as well. So Korea takes the ISDS mechanism seriously, though the reality of the system having its own deficiencies cannot be denied. In order to effectively run the ISDS mechanism in its unstabilized status, the Korean government conducts internal regulations, such as by reviewing relevant laws and regulations, and closely monitors the implementation of investment agreement. A recent relevant development in Korea is the creation of the International Dispute Settlement Division within the Ministry of Justice, where I serve as director. Our division takes the main role when it comes to ISDS defense, and it's dedicated to investment-related work. Furthermore, by closely collaborating with the Ministry of Foreign Affairs and other agencies on investment-related negotiation, we try to consider different interests within the government in relation to ISDS regime. So to conclude, as I mentioned earlier, we have seen a significant increase in the number of investment disputes around the globe, and that leading to further development of international investment law. However, since the international investment law is still in its early stage of development, its jurisprudence will undergo changes over time. In my personal view, states would need to keep in mind that international investment law will continue to evolve, and therefore should take into consideration the 4 different roles and nature of dispute I presented earlier when approaching ISDS reforms and rules amendment. Well, this concludes my remark today. So thank you so much.
Thank you very much, Mr. Han. I thank you again, all the speakers today, and hope that everyone connected through Zoom would find this session on ISDS very informative in updating and understanding the current trends of and issues in international investment arbitration. Before we conclude today's session, I will share with you the final results of the 2021 FDI Moot Global Rounds in Seoul, which concluded on Wednesday this week. It was co-hosted by KCAB International and Center for International Legal Studies in Salzburg in Austria. Due to the lingering concerns of COVID-19, it was held virtually, but 81 teams competed in these global rounds from all over the world, from all major continents. And the salient aspect of the 2021 FDI Moot was the geographical diversity of competing teams in the global rounds and the apparent leveling off of the capabilities among the competing teams, as evidenced by the results as summarized by this chart of the winning team. The winner was a team from Symbiosis Law School of India, and the second place was a team from University of Miami. The third place was taken by a team of National University of Singapore. Jean would be very proud of this. And the first place was a team from Kabarak University Law School of Kenya, from Africa. I had the privilege of sitting in the final match and was very, very impressed with the knowledge level of the competing teams on the investment law, as well as the advocacy skill of the teams. I am very confident that the future of international investment law is bright with these new next generation of very bright young lawyers keenly interested in international investment arbitration. This will conclude today's ISDS session, and I would like to express my thanks to the speakers on the panel for the valuable comments and insights on the topics and keen attention of our audience. I hope to see you all in person this time next year in Seoul. Thank you very much.
Thank you all for your wonderful discussion. Now, before we move on to session 4, we will have a brief break and we will begin the last session at 5:50 p.m. Korean Standard Time. So see you soon.